The Presidential Election Petition Court delivered a 12-hour marathon judgment on Wednesday, throwing out the petitions of the Allied People's Movement, the petition of the Labour Party and its presidential candidate Peter Obi, and the petition of the People's Democratic Party and its flag bearer Atiku Abubakar. The tribunal dismissed the petition of the three parties challenging the victory of President Bola Ahmed Tinubu of the All Progressives Congress in the February 25, 2023 polls. The five-man panel, led by Justice Haruna Tisanmani, did not only dismiss the consolidated petitions of the PDP and the APM and the Labour Party, the panel also clearly affirmed the victory of Tinubu and told the parties to bear their cost. Yesterday's ruling will be said to be one of the longest ever proceedings that started from 9 a.m. to minutes past 9 p.m. and was televised live. But after the judgment, the presidential candidate of the People's Democratic Party, Atiku Abubakar, and the Labour Party counterpart, Peter Obi, had rejected Wednesday's judgment. The legal advisor to the Labour Party, Kainde Edun, vowed to challenge the judgment at the Supreme Court. Also, Atiku Abubakar lead counsel, Chris Uche, SAN, said he had received instruction from his clients to file an appeal at the Supreme Court. He said the judgment has been delivered, but we have not received justice. Luckily, the law has given us leverage to go on an appeal to the Supreme Court, so the struggle continues, he said. But reacting to the judgment and victory at the court, President Bola Ahmed Tinubu said he welcomes the judgment of the tribunal with intense sense of solemn responsibility and preparedness to serve all Nigerians irrespective of their diverse political persuasion, and called on both Atiku and Peter Obi to join him to build a united Nigeria. But the big question on the big story for today is, will the victory be seen to mend fences or further divide the parties? And will be going to the Supreme Court as stated by them finally put an end to all of it? Well, as much as we shall be asking these questions, we shall also be looking at the judgment critically on the show today. And that is the Presidential Election Petition Tribunal judgment, the next move. That's what we're having as a major discourse today on the big story. And we're talking about the Presidential Election Petition Tribunal judgment that was read yesterday. And what will be the next move? Well, that's what we're having. And to truly help us talk about this, remember, like I stated in my introduction, we'll be critically looking at the judgment. And, well, what better way to do so rather than have lawyers right here in the studio with us and one joining us all the way from Abuja to truly look at it. And joining us in the studio right here, we have no other person but Barrister Lucky Asanuwe, a legal luminary. Good morning and welcome to the show, sir.
Thank you for having me.
And also in the studio with us, we have no other person but Barrister Emmanuel Erire, also helping out with trying to understand it. Good morning, welcome to the show, sir.
Thank you, my brother.
And also joining us all the way from Abuja is no other person but Barrister Ejiro Itagene. And well, he'll be joining us via phone also to look at these issues. I guess he's online with us. Hello, good morning to you. Hello, Barrister Ejiro. Okay, we'll try and see how we can get him on board. And when we do, definitely we'll be having to, or rather I would love to have his view as it concerns that very victory yesterday, especially of his party and candidate, President Bola Ahmed Tinubu. Well, anyway, let me quickly start with you, Barrister Emmanuel Erire. Honestly, all eyes were on the judiciary since this trial started. And it was no surprise that every Nigerian... Okay, it looks as if we are now having Barrister Ejiro Itagene. Hello, are you there with us?
I am here.
Well, welcome to the show also. And thank you so much for joining us. Okay, I will plead with you, Barrister Emmanuel Erire. Let me just quickly have his thoughts, especially as it concerns that very ruling yesterday. Like I said, honestly, all eyes were on the judiciary since the trial started. And it was no surprise that every Nigerian monitored it till the very end. But I rather want us to start by getting your reactions to the proceedings yesterday. 12 straight hours. What are your reactions to the judgment yesterday, Barrister Ejiro Itagene?
Firstly, it is the longest judgment I've ever experienced in my life.
Yes, that we know.
Judgment that took, like you said, over 12 hours, non-stop. a little break, and I was giving to the justices of the Court of Appeal. They did their best. When they start judgment, every issues were touched, every issues canvassed by the petitioners and the respondents were touched, and they were done justice were done in accordance to the law.
Okay, well, so your reactions to the victory yesterday of your candidate and your party?
My reaction is that it's well deserved, and I saw it coming. Okay. As a lawyer, I knew it's not an easy task for a petitioner to prove his case in an election tribunal. Election is not an ordinary civil. Election petition is not an ordinary civil action where a claimant or a petitioner goes to court and prove his case on the balance of probability. No. Every allegation has its own standard of proof. If we make an allegation of malpractice or corrupt practices or rigging and overvoting, they fall in the realm of criminal actions, and the standards of proof are very high. It is proof beyond reasonable doubt. And you heard what the justices said yesterday in the lead judgment. They said, and I agree with them in totality, that the petitioners, all of them, were unable to prove their case as required by law.
Okay, but because of time, we'll be coming to have your thoughts, especially as we'll be breaking down each of the judgments yesterday, and we would start with the Allied People's Movement. But I'll plead with you to hold on. But Emmanuel Rire, your reactions yesterday?
Well, like my learned senior just said, I think in my years of practice, this is the longest judgments that have ever been delivered. I believe every lawyer in Nigeria who knows the nature and peculiarity of election matters, we know that the justices actually did justice to the best of their ability in addressing and deciding every issues
that was raised
by all parties. In fact, it is not news that a party that is not satisfied has the right of appeal.
Of course.
But I want to commend the justices. First and foremost, 12 hours non-stop, even though there was a little break, is something to commend them about.
But Saloki, 12 hours non-stop, and the judgment finally came. Any reaction to that, or any reservation about that very judgment yesterday?
Before I come to the question you asked me, let me quickly say that, unlike my learned friend, Ejiru Tauzene, who is a politician and APC member, I'm not a politician, I'm not any party member. So my observation will be purely objective.
Yes. That's what we love to
Yes, I must commend the justices of the Presidential Panel Tribunal. Okay. They did marvelously well. They touched the issue. Now, having a very long judgment spanning through about 12 hours, I'm not surprised. The reason being that if you see, it is a consolidated petitions. The APM petitions, the APC and Labour Party. And in law, we have what is called consolidation of suits. When suits are filed by different persons against one person, possibly on the same subject matter, in order for the court not to hear the matter in different times, they consolidate them, they hear them together. But when delivery judgment, they deliver judgment as if they are separate. Yeah. So if you see what the learned justices of the tribunal did yesterday, they dealt with each of the petitions one after the other, and they came into a very sound decision. I must commend them.
Okay, anyway, it's not easy for the 12 hours, just like three of you have agreed. But anyway, like I said, we agreed to look at the issues one after the other. And I would rather want to start first with the judgment that was of the Allied People's Movement. But I'm really keen to have your view on this. Which was alleged the invalid nomination of Tinubu'S running mates, Kashim Shettima, and also centered on the qualification or otherwise of our President Bola Ahmed Tinubu to contest the presidential election that was held on February the 25th. But the tribunal said that the APM lacked the local standing to challenge Tinubu's nomination, and the APM ought to have gone to court within 14 days after Tinubu's nomination by the APC. But if you look at section 131 and 237 of the 1999 Constitution as amended, made provision for qualification or disqualification of candidates. So I want you to explain why the APM erred when the Constitution gave that provision to challenge a candidate's nomination.
There are two ways to look at this issue. Yesterday, after striking out the APM's petition at the preliminary objection level,
yes,
the justices went to consider the matter on the merits. Now, what happened was that the APC had filed a petition challenging the jurisdiction of the court, asking that the tribunal should strike out the petition filed by APM on the ground that they lack the local standard, and on the ground that the issue has been decided by the Supreme Court. Okay. What is the issue? The issue of double nomination of Shettima. And the court in its wisdom said the provision of the Constitution is clear as to grounds upon which a presidential candidate can be disqualified. And that looking at the entire gamut of the law, particularly the Constitution and the Electoral Act, that ground is not one of the grounds so stated, for the disqualification of a presidential candidate. After agreeing with the President Bola Ahmed Tinubu's lawyer, that it was a ground of, that it qualifies as a ground of striking out the action, they went to decide the matter on the merit. Okay. And he decided the matter on the merit. They drew analogy from the Supreme Court decision in PDP against INEC on the issue of whether Shettima was properly nominated or not. And in dissecting the issue, they went deeply and considered it on the merit by saying or agreeing with the council that Shettima actually withdrew his nomination. Okay. Withdrew his nomination as a senatorial candidate in Boronu senatorial election.
But essentially, hello, can you please? I want you to really help me understand, because what also the tribunal said yesterday, it said the APM raised its petition of pre-election matters that could only be determined by a federal high court. So my question is, if you feel the appeal court was not the right place to go, then why entertain the matter in the first place?
That is why the petition itself is frivolous. The court said that the tribunal said that issue canvassed before them through the petition is a pre-election matter that ought to be filed within 14 days of the course of action. So the petition was doomed to be struck out, and it was properly struck out.
Why not take it out in the initial stage rather than entertain it to the final stage, and now you are telling them it ought to have been in the federal high court?
That is the procedure. That is the procedure adopted by the Electoral Act itself. That when a preliminary issue is raised, when a preliminary objection is raised in an election petition, it will not be considered immediately. It will be determined at the end of the hearing of the case. Okay. So when the court will decide the matter on the merit, it will first of all give a ruling on the preliminary objection, and that is what the court did. After giving a ruling on the preliminary objection, they went ahead to also deliver a judgment considering the case on the merit.
Okay, well, thank you for that. Barrister Loki, I'll need to bring you into this, because I'm also reading, you heard his reaction, especially to that very judgment against the Allied People movement. And it still brings, because many Nigerians understand that these issues are legal and they dealt with it as it concerns the law. But we are still wondering, why throw the whole petition of the Allied People's Movement out and you're telling them that, okay, well, they just could not even entertain it, that they were not party to the All Progressive Congress, hence they lack the merit to even bring the case in the initial stage. So let's really understand that very judgment against the APM yesterday.
Now, when we are discussing issue like this, there are certain laws or statutes that come into mind that you consider. One is the Constitution of Federal Republic of Nigeria 1999 as amended, then the Electoral Act 2022, and also the Evidence Act itself. Okay. Now, like my learned friend rightly said, there are procedures to every form of litigation or form of issue before court. Just like the fundamental right proceedings. Okay. If there is any preliminary objection raised in a fundamental right proceeding, the judges don't take, the court is not expected to take the preliminary objection immediately. It's at the end of the hearing of the matter, he takes everything together.
So the APM was wrong to even have instituted that very action against the All Progressive Congress candidate, Bola Tinubu. Is that what you are saying?
Now, by the Electoral Act and the other laws that I made reference to, we have pre-election matters. Okay. Once the issue arises before election, the court that has jurisdiction is the Federal High Court. You go to the Federal High Court within 40 days. If you fail to do that, then you have waived your right to go to court. The Court of Appeal is not the court that ought to assume jurisdiction in respect of that. But like I did say, I must commend the learned justices of the tribunal. Ordinarily, having decided the preliminary objection and having heard that the APM does not have locum standi to file the action or they fail to go to the appropriate court, ordinarily they ought to have ended it. But they want to satisfy, they want it that a situation where everybody will see that justice is fully done. Okay. That assuming without conceding that this is the right place you ought to have come, that assuming without conceding that you have the local standard, let us look it at the merit. Then they looked everything at the merit. They decided that, look, this man you are talking about, he would rule his nomination and candidacy before he was picked for the election. And in any case, he did not acquire, he did not buy form, he did not obtain nomination form as canvassed by you. That based on that, you cannot say that the man has violated the law. And besides that, the Supreme Court has decided it. There's what we have, we call issue estoppel. The Supreme Court having